Here we are. Hello, good afternoon. It's David Hitt, your divorced Los Angeles realtor. Thank you for joining us. Today we're here with fabulous estate planning and will and trust probate attorney, Marisha Charbonnet. Welcome, Marisha.
Hi, thank you so much for having me.
Yeah, absolutely. So, today, as I mentioned to you, we want to, talk about when someone's contemplating divorce or going through a divorce, what are the things that they need to be cognizant of or aware of? So you've provided some great questions to dialogue around. So I'll just go ahead and get started here. And let me just time us really quickly so that we're mindful there. Okay, so Marisha, what impact does divorce have on powers of attorney?
So that's a great question, David. So powers of attorney, it's important to understand, are really a critical part of an estate plan that have nothing to do with, a person's asset level or even whether they are married or single. Because with powers of attorney, what you are doing is you are designating a representative, basically a decision maker, to be able to step into your shoes and make decisions for you in the event you became incapacitated. So, say you were in a car accident that left you in a coma or you developed dementia. And there's two different types of powers of attorney. There's power of attorney over financial decisions, and then there's power of attorney over healthcare decisions. Now, in the context of divorce, this all becomes really important because when a divorce is finalized, it automatically terminates the nomination of a spouse as an agent under a power of attorney. And so basically what that means is if you have not updated after your divorce, or if you haven't designated it to your spouse, you could be left without anybody to act on your behalf post-divorce if the only person you named was your now ex-spouse. And that leaves you open to a conservatorship and all kinds of other, nightmare situations. It's also really important to keep in mind that as you're going through a divorce, if you have designated a spouse as your agent, that might be something you want to change because it's quite possible that at that point in your life, that may not be the person that you would want to be making financial and healthcare decisions for you at that point. And updating a power of attorney is something that you can do at any point in time, at any point mid-divorce, post or prior. So it's just really important to make sure that you update that document if you're going through a divorce.
Okay, great. That is very important and great information to know. Thank you for that.
Sure.
So the next thing I wanted to find out about is what impact does divorce have on a will? What can you share about that?
That's a good question too. So when couples are going through a divorce, you want to keep in mind that a divorce is going to automatically revoke any gift that was made to a spouse in a will that was created while they were married, okay? However, until that divorce is finalized, that couple still technically remains spouses, which means that unless something is changed and a spouse passes away mid-divorce, the existing estate plan, the existing will is still going to be valid and have an effect. And so if there's a will that is leaving everything to a spouse, then that spouse is going to receive everything under that will, which at that point in time may not necessarily be what the other person would want if the expectation is that the assets are going to be divided and everybody's going to walk away with their, individual half. You're now creating a dynamic where that surviving spouse could now be walking away with everything instead of half of everything. And so it is possible to update a will during a divorce so that you can try to alter those beneficiaries to be more in alignment with you know, the way that your life is looking at that point and the people that you would want to be inheriting your assets at that time.
Okay, good. Well, that's good to know. These are all things that people need to know and that don't want to talk about, but that's why I wanted to do this video. Okay, so the next question is, what impact does divorce have on beneficiary designations? Can you share about that with us?
Absolutely. So when a person passes away, the distribution of certain types of assets, things like IRAs, 401ks, life insurance, and even certain bank accounts may be subject to beneficiary designations, which are basically documents in which you are designating who you want that asset to go to upon your death. And so it's really, really critical to make sure that those beneficiary designations are being kept current and up to date with the people that you presently want to be the recipients of those types of assets. And, you know, typically after a person files for divorce, there are going to be some temporary restraining orders that get put in place that are going to limit the type of changes that you can make to things like beneficiary designations without either your spouse's consent or approval from the judge. However, once that divorce is finalized, it does become really important to make sure that you have updated those designations to be in alignment with what your current intentions are. Because I can't tell you how many people out there forget to do this. And then the ex-spouse ends up getting this unintended windfall simply because they forgot or they just never got around to updating those forms. And there are some distinctions that get made when it comes to retirement accounts. Because, for example, qualified retirement accounts, which are things that fall under the ERISA law, which is going to generally be things like a 401k or a 403b type of account. The laws that control those types of plans do dictate that upon divorce, the designation of a spouse is basically automatically terminated. But that does not necessarily apply to IRAs. And so if someone has an IRA and they get divorced and they don't update it and they still leave their now ex-spouse on there, that ex may end up receiving everything. So it becomes really, really important to just double check those, triple check those beneficiary designations and make sure that they've been updated.
Wow. This is really so enlightening. So thank you about that. Okay. So the next question I wanted to ask you is, what is the importance of guardian nominations for minors after a divorce? Can you share a little bit on that, please?
Absolutely. That's another really important issue. Nominating a guardian for minor children is just generally a really important thing to do in order to keep your minor kids out of the hands of Child Protective Services and ensure that it is people who you know and trust that those children are going to be placed with and be cared for if something happens to you unexpectedly. You know, people have conversations all the time with, you know, family members, their best friend, where they, you know, say something to the effect of, hey, if something ever happens to me, will you take care of my kids? And those people, you know, oftentimes will say, of course, sure I will. But the reality is, if those conversations had not been documented in writing, they're essentially meaningless. You know, which is why it becomes so important to make sure that you have nominated guardians. And in the case of couples who are divorcing, this becomes, you know, an even more important issue, because if you have a situation, for example, where one spouse may have been given sole custody, well, that person may not necessarily be able to rely or want to rely on the other natural parent to be the guardian of those children if something should happen to them. And so making sure that someone in that situation has nominated a guardian becomes really essential. And even on the flip side, where you have a situation where a couple may share custody of their kids and one parent, you know, may be perfectly fine with the other parent having sole custody if something should happen to them, it's still a really good idea to nominate a guardian because you may need a backup. What happens if that other parent should unexpectedly pass away? And there's never an obligation to nominate the other natural parent. The reality is, in most circumstances, a judge is going to place children with a natural parent. But if you have a deep and burning desire to nominate somebody else, and there are issues that you really want a judge to be aware of regarding concerns that you might have about the other natural parent being the guardian, you could certainly include that in a guardian nomination so that at least a judge could take it under consideration if something should happen. And the other thing to keep in mind about guardians too is another important reason to make sure to nominate someone is if you're in a situation where maybe you have children from different parents, but you want those kids to remain together. Maybe they're half siblings and it's really important to you that they be raised, you know, in the same home. Making those intentions known and indicating who you would want to be caring for those children just becomes really important under those circumstances as well.
And again, making sure it's in writing. Just a conversation is not going to fly when the push comes to shove.
Right. The
I'm
writing
laughing because
essential.
good in theory, but you know the conversation won't hold water if it's not in writing.
Right.
Thank you for that. Okay, so important. So the next question I have for you is, can a person change their estate plan mid-divorce? Can you share a little bit about that, please?
Sure. So when it comes to making changes, when a couple files for divorce, there's something called automatic temporary restraining orders that immediately take effect. And those are going to put all kinds of limitations on the parties to that divorce in terms of various types of things they can and can't do without getting either the other spouse's consent or approval from a judge. And so when it comes to making changes to your estate plan, those temporary restraining orders are going to have a big impact. Now, there are some things that you can do unilaterally. One of those is you can unilaterally create, modify, or revoke a will without having to get your spouse's consent, without having to get the judge's blessing. And that's something that you can do at any point during your divorce proceeding. However, if you wanted to do something, for example, like revoke a trust, that's going to require notice to your spouse before you can move forward with that. And while you can create a trust without having to get your spouse's approval or the judge's approval, you can't actually fund that trust with any assets without that approval from your spouse or the judge. And the reason for that generally is when you're going through a divorce, one of the big issues at play is the division of your property. And so when you create a trust, you're actually funding a trust with your property. Well, mid-divorce, you don't really know what your property is yet because the judge hasn't made that determination. And so while you can create the shell of the trust so that it's in existence and basically ready and waiting to be filled with your assets, once you know what it is that you actually own, you can't get to that step until you're a little bit further along in the process and the judge has actually issued some orders about what your property is actually going to consist of. Now, all that being said, my word of advice to people that are contemplating a divorce is make changes to your estate plan before you ever file, because you're going to have the most flexibility at that point in time. And so these are some things that if you're able to, it really will behoove you to think about in advance, because once you're in it and you've filed, there are going to be a lot of restrictions that are going to be put on you.
Okay, so get any changes done up front is the message, if at all possible. Okay, great. Thank you. Very important to know and very enlightening. The last question I have for you is, what happens if I or my spouse dies before the divorce is finalized? Can you share a little bit about that?
Sure. And this kind of touches on a little bit what I was saying about, you know, what is the impact of a divorce on a will? So what happens is any gifts, again, that one spouse makes to another, either in a will or in a trust, okay, those are going to remain in effect if one of the parties passes away mid-divorce. And so it becomes really important to actually, you know, assess what you've done in that regard, because unless changes get made, you know, you could run into a situation where now this person that you're trying to separate yourself from could, instead of ending up with half the assets, end up with all the assets if you were to pass away mid-divorce without making some changes. The other thing to keep in mind too is for people who haven't done any estate planning and are getting a divorce, they haven't created a will, they haven't created a trust. If they die mid-divorce, the laws of intestate succession, which are the laws that take effect for people who have not designated any beneficiaries and just pass away, those are going to apply. And under the laws of intestate succession, a spouse is generally the first person in line under the law to receive assets in the event of death. And so again, you could be finding yourself in this situation where your ex is now getting, or soon to be ex, is now getting everything instead of half of everything. And it is possible to avoid that type of outcome, but it does require some proactive planning. It requires some coordination both with your family law attorney and your estate planning attorney. And so again, this is just one of those areas where, in order to make sure that your intentions really end up happening the way that you want, you've got to do some pre-planning, and you really have to think it through. Because when you just jump into the divorce and then try to deal with some of these issues after the fact, it isn't always so easy.
Wow. Well, thank you for that. That's very important. I think just, you know, before we sign off here, I think just in general, that it's so important to, particularly in a divorce, but just even in general, that people think about and plan their estates and get with an attorney and create trusts and whatever is necessary in advance. It doesn't have to be as scary as we have it in our minds. And I think you don't have to wait until you get to a point in life where, you know, I guess if you could be sort of get in your 50s, this really becomes a lot more present because you're closer to death than you were in your 30s or 40s. But,
right.
You know, I think it's better for everybody involved that you love and care about to do the foresight, have the foresight up front, and just go ahead and have the courage to do it and get it out of the way.
Absolutely.
And this is not something you need to be afraid of. We're all going to die, and you know, it's just part of life and part of the process. Don't you want your assets and your, you know, property and all of that stuff to be handled in the manner in which you would that you have in mind today? And the answer that comes to me is yes. So,
I mean, you couldn't be more right about that. It really comes down to being proactive and making these decisions when you're healthy, when things are okay, because when you're doing it because something horrible has happened and you now feel all of this intense pressure, it does become much more difficult and much more frightening under those circumstances. And the other aspect to estate planning that I always like to really emphasize with people is that it is not all about death. It is very possible to benefit from an estate plan without actually having to die. And that all comes down to the issue of incapacity, because the last thing you want is for you to have some sort of health issue that renders you incapacitated, but you're still alive and you don't have the people in place that you feel comfortable with to be making decisions for you at that point. And so that's just one way where during your own lifetime, this actually can provide a very important benefit to you while you're still alive and here. And, you know, that's just another facet of this that I think is really important for people to understand when they're looking at estate planning in a really holistic way.
Well, wow, this was so awesome and very, very enlightening. And I think this is probably one of the most important meaty video interviews that I've done that has impacted me in a way, and I know it should others that hopefully watch this. And I just want to thank you. I find you to be a wonderful, professional, kind person, and I'm so fortunate and happy to know you, and looking forward to getting to know you more, and hopefully collaborating and working together on more things in the future. I appreciate you very much. Have a great day.
Thank you.